Welcome back to the Apartment Dealer Show. I am Chris German, the apartment dealer. With me today, we have Mr. Mike Brennan, eviction attorney extraordinaire. Mike is known within LA County, San Bernardino County, Riverside County. If you're a landlord, you know Mike's name. And he's with me today to cover those questions we did not have a chance to get to when we just hosted our webinar for landlords like yourself. Mike now for over 15 years has been an eviction attorney. He has represented landlords in and outside the courtroom and can really speak to those most controversial issues, when it comes to how do you deal with evictions, given the current state of California, the most recent legislation. How do you go about the day-to-day management of your properties? Now, I will mention this. These rules differ from county to county. Yes, most of you are within the state of California. Most of us are in Southern California. Even the majority of you probably are in either Los Angeles, Orange, or San Bernardino counties. But even with that, from city to city, some of these regulations can differ. You want to also check with the current ordinances that may be in the cities of which you own. Having said that, Mike, welcome back to the Apartment Dealer Show.
Chris, thank you very much. I appreciate it.
And of course, Mike, we were together just a few weeks ago at our educational webinar, and we'll link to that video here so that people can go through that material. But a lot of the questions, of course, still circulate around this new AB 3088. Even with that, we have AB 1482, the statewide rent control that took effect January of this year. And really, in between the two, every few weeks, we've been pointed in different directions. I imagine your phone must be ringing day and night.
Yes, it is very difficult for me to keep up with everything I'm supposed to be doing, let alone calling people back to address their specific questions. Chris, before we get started, I just want to, first of all, thank you guys for doing this. It's very beneficial to all the landlords out there. Second, I want to say that you're absolutely right. There have been changes in the industry. They come, it seems like daily, certainly weekly, and no doubt about it, monthly. So in light of that fact that things are constantly changing and we're constantly understanding all this stuff better and better as we go along, I do want to let your members know that any of the information I provide today is general in nature. It's not intended to be legal advice on any specific topic. I will give some specific examples, but it is still general in nature. Before trying anything anybody hears me say in this interview, they should definitely reach out to either my firm or their own landlord-tenant firm and go through the specifics of their specific property. This is definitely not a do-it-yourself period or situation. One final caveat and thought that your members should understand is we've all heard this many times in the past 9 months. We're in unprecedented times and we're facing an extraordinary situation of first impression. So there's very little case law to guide us on this stuff. And ultimately, no matter what one attorney or another attorney or some association may say, the judges are going to have the final say on how these laws are applied, where they're applied, and when they're applied. So with that, I'm happy to answer any questions that you might have.
And, going back to the educational webinar that we held, I think the general consensus was, as a landlord, don't try to go at this alone. Right. Even myself, I think I keep up to date with what's new and trending, but I've had a couple of squirrely tenants myself here recently that I reached out to you about, just because, in my opinion, it's not worth making the wrong misstep. And the way these new laws are written, it's very easy to do so, to only wait months to get to court. And when you finally do, because you wanted to be a hero by yourself, come to find out you did it wrong, and now you get to start all over, or the tenant wins by default, somehow. So I think that people need professionals like you in their corner.
Chris, you're absolutely right about the possible negative consequences that can come out of this, but I'll add to that. Some of these moratoriums give the tenants a private right to file a lawsuit against the landlord. And if they make a mistake and lose their case, the landlord can guarantee that that loss will come in to the civil case against them as evidence that the landlord violated the moratorium. So this is definitely not a situation where I don't, regardless of your experience level as a landlord, right now is not the time to attempt to navigate this by yourself.
All right, well, let's dig into some of these questions. The first one here, what are the best practices when screening tenants given all the recent regulations?
There's a lot to that. I would start off by saying this is a great time at the end of the year right now to sit down for every one of your clients and review their rental criteria. They should have their rental criteria in writing to begin with. There's two forms that they can have. One internally, their own kind of policies and procedures, I'll call it, and one they hand out with an application to an applicant. Beef it up. And it's funny, I hate to say this, but most what I'll call mom and pop landlords put very little time and energy into their screening criteria and to the actual screening itself. As long as everything on the application looks okay, they don't really dig too deep. And it's no longer acceptable to do that. That might even be the worst possible approach you could take. What they should consider doing right now is there's a couple paths they can take. If they're a member of a trade organization, oftentimes they'll use the trade organization's applications. I won't name the different organizations here, but we all know who they are. They all go by the apartment association. But if they're not a member of the trade association, they could create their own criteria. If they are and they're using the association's application, they can customize that. They can add to that by having another sheet that says, hey, we also consider these things. I'll give you some examples. They could customize their screening application to include new questions, such as asking the tenant directly, why are you currently moving? Why are you looking for a new apartment? Just to get an answer, a general answer on that. They can add a line asking whether anyone currently or in the next 12 to 24 months might have any legal claims against them. And what they're really getting at on that one is your current landlord about to sue you next year in small claims court for unpaid rent? That's another question they could add. They want to be careful about the questions they're asking. They don't want to run afoul of anti-discrimination laws, but they can certainly add questions to it. They can ask direct questions. Are you currently behind in rent to your current landlord due to COVID? And that's not necessarily going to be a disqualifier right on its face, but it's just an honest, direct question. Are you currently behind in your rent? With that, I would also suggest that many of your clients who aren't currently doing this, run credit reports. One of the key things is realistically, what's going to happen right now? You're going to have a lot of tenants who aren't paying their rent, who are going to be filling out applications to rent from you or one of your clients. And they're going to say, oh, I lived with my sister for the last year. All right. So run that credit report, and they can have their sister write a letter that says, yes, I'm this person's sister. Our address is such and such, and this is where he's been living or she's been living for the last 12 months, 18 months, whatever it is. Run that credit report. What does the credit report say their address is? What does their license say their current address is? What does any of their pay stubs, for example, some pay stubs will have an address on them. Mm-hmm. What does that say? Start looking for the addresses, because that's going to be key. Look for the name that lines up. A lot of your clients, like yourself, you're in real estate. You can run a title report. They can say their sister lives at 123 Main Street, but when you pull the title report, it's actually owned by an LLC. You want to dig deeper into those situations. There's a lot they can do. You can have provide a letter from employment, right? You can ask a direct question on the application. Was your employment, did you lose hours or lose a job as a result of COVID, right? That's just a yes or no answer. And again, it's not necessarily a disqualifier, but if they did have reduced hours or they lost their job as a result of COVID, there's a very real possibility that they weren't paying rent and that landlord will have a legal claim against them in the future for that unpaid rent. And the reason that's so important is if you're running your numbers right now, most of my clients run anywhere between 2.5 to 3.5 at the high end of their gross income to rent. Okay, well, if they have a small claims judgment against them in the next 6 months, and all of a sudden their wages are getting garnished, guess what that's going to do to their income, their gross income? It's going to reduce it by up to 25%. So when you're running your numbers, that's another strategy you can use. If you typically use 2.5 times their gross income, maybe bump it up to 2.75. Maybe bump it up to 3 as your rental criteria. Because if they're not paying rent, it's very likely they're going to have a small claims judgment against them in the next 6 months, and their wages will be garnished at some point. So there's plenty you can do. Like I said, the big thing is really just dig in, sit down, go over your screening criteria, write it out. And here's an insider's tip on writing out your rental criteria to avoid fair housing claims. You want to have objective, non-discriminatory reasons for your criteria, or objective non-discriminatory criteria, right? So for example, if you say you've got to have 2.5 times the rent in gross income, that's objective, it's not discriminatory, right? You're going to apply that to everybody. Under each one of your criteria, you want to write the question, why? And you want to be able to articulate that question, because if and when somebody gets denied tenancy and they go and file a discrimination complaint with Department of Fair Employment and Housing, when you're responding to that complaint, you are going, they oftentimes ask, we want to know what your rental criteria are, and we want to know what they're based on. If you can currently, right now in writing, articulate a reasonable, objective, non-discriminatory basis for the criteria, then it'll be very easy to answer that in the future without running afoul of their laws and getting yourself in trouble. So all in all, like I said, what I would do is I would revamp my application criteria and my renting criteria. I would create some customizable questions. I would certainly reach out and dig in and find out who their current landlord is. I'd call the current landlord, assuming they don't tell me it's their sister. I would call the current landlord and say a couple questions. One, during COVID, did they pay all of their rent? If the landlord wants to get rid of them, of course, they're going to say, yes, they were a great tenant. I'm sorry to lose them, et cetera, right? Okay, did they give you notice that they were vacating? Or are they just out here, looking for an apartment? You don't even know about this yet. Did they vacate, or did you guys come to some sort of an agreement where they would vacate in exchange for you waiving some of the unpaid rent during COVID? I would ask all of those direct questions to their current landlord, assuming they've given you the correct information about who their current landlord is.